Can I travel to the United States once the I-130 petition is in process with USCIS or even approved? That's a question we receive all the time from clients. It's an excellent question, and it's what we're talking about on today's episode of Sumner School Family Immigration Basics. Before we get into it, know that there are several different variations on this question, and wording matters. So for example, if the question is, I have filed the I-130 and I-485 here in the United States, also sometimes called a one-step, can I travel? There's a different episode that you need to be watching for that. That is Sumner School Family Immigration Basics episode number 18, and we also have an episode number 12 about that particular issue. Likewise, and it's a very similar answer, a very similar concept, if you entered the United States on a K-1 visa and then subsequently filed the I-485, there's the question of whether you can travel, and that is episode number 28. So know that those are different situations, similar but different situations. This video is for the situation where the I-130 petition is filed, the foreign national is outside of the United States, and they're wondering if they can come visit. The answer is yes, but proceed with caution, okay? There are two things you need to think about. One is, how are you going to enter the United States? To enter the United States, you typically need a visa. There are certain exceptions. Canadians are visa exempt, and some foreign nationals can enter on ESTA, which is a visa waiver program. But otherwise, you're going to need a visa to enter the United States. If you already have a visa, then you need to think about what is your visa classification and whether that allows for dual intent. Dual intent is the concept that certain visa classifications, namely the H-1B and the L, allow a person to hold that visa classification, travel back and forth on that visa, and undergo the green card process at the same time. If you are in the United States, or if you hold rather an F1 visa, which is a student visa, a TN, an E2, any number of other different visa classifications, and you have the family-based green card process going on at the same time, meaning you have the I-130 petition filed or even approved, please talk to an immigration lawyer before you make travel plans. In most cases with our clients, the individuals asking this question, wishing to travel to the United States, usually to visit their loved one here in the United States, are looking to enter the United States on a B1, B2 visa, which is a visitor's visa, or ESTA. So if you, and this is not legal advice, as always, this is for informational purposes only, but in general, if a person already has a visitor's visa, then generally speaking, a visitor's visa, they can use that to enter the United States. Hold on for part 2 about actually entering the United States. If you do not yet have a visitor's visa, you have to disclose on your visa application or any visa application for any type of US visa that you have the I-130 petition filed, that you're the beneficiary of what's called an immigrant petition. You have to disclose that. And that could be a reason for the consular officer to deny your visa application. So bottom line is, it's complicated, right? But let's say that you are in the situation where you already have an approved visitor's visa and you're looking to use that to enter the United States. The next question is, what happens at the port of entry? Remember that no one is guaranteed entry to the United States, really, unless you're a US citizen. And no one can control or predict exactly what's going to happen. So when clients ask, when they say, hey, I have a valid visitor's visa, I want to visit my loved one in the United States, we say, yes, you can attempt to enter, apply for entry, apply for admission to the United States, even with the I-130 petition in process or approved, but know that entry is not guaranteed. In those situations, I always recommend that a client have the return ticket home to their home country, and that they bring proof of ties to their home country in case they are asked about that. You want to be able to show that you do not intend to stay here in the United States and apply for a green card. So that type of documentation can be important. It's possible the officer wouldn't want to hear it, or they wouldn't want to look at the documentation. Like I said, there's no guarantee. In my experience, almost always people are admitted when they have, even if they have the I-130 petition approved or in process and they have a valid visitor's visa, but it is not guaranteed by any means. So if things don't go well, it's possible that you would be put in secondary inspection, where they pull you aside, ask you a lot of questions. You may be there for an uncomfortable amount of time, potentially hours at once. It is possible that they would ask you to withdraw your application for admission, meaning as the name implies, you say, just kidding, I don't want, you don't say just kidding. You say, I don't want to come into the United States. I've changed my mind, and you return to your home country without entering the United States. It's possible that they would give you what's called expedited removal, which is basically deportation at the port of entry. There's no right to an appeal and no right to a lawyer. There may be certain steps that you can take after that, but there is a 5-year bar to re-entering the United States if you receive expedited removal. So the bottom line is, yes, you can, but proceed with caution and definitely talk to an immigration lawyer before you decide to try to apply for admission to the United States. So you can know exactly what's going on at that time. Like I said, no one can ever make a guarantee or a precise prediction, but at least talk to an immigration lawyer to get an idea of what the risks are at that particular time and for your particular case. I hope that you have found this information helpful. If so, I hope you'll share this video with a family member or friend. Make sure you are subscribed to our channel if you're not already, with alerts on so you don't miss our next video. In our next video, we are talking about the National Visa Center process, which is the next step once the I-130 petition is approved and before you apply for that immigrant visa at the U.S. consulate. Until next time, my name is Emily Sumner with Sumner Immigration Law. We serve clients from around the world and around the United States with family-based and employment-based immigration matters. If you are looking for someone to walk through the process with you step by step, by your side, every step of the way, able to answer questions, make sure that the process is done correctly and as smoothly as possible, we are here to assist you. The first step is to set a consultation with us, and information on how to do that will be on the outro slide right after this. Until next time, my name is Emily Sumner.